Good evening, everybody. Thank you for joining us today. I'm Mahalakshmi, along with my colleague Aranyani Bhargav. Today, we would like to begin our session by paying our respects to the elders who have practiced this art form and the hereditary practitioners of this art form, past and present. Aranyani and I are the co-founders of Re-Cognising Dance, which is a safe and democratic space to discuss all aspects of dance. What began as a platform to discuss the social history of dance, today we have expanded our conversations to beyond Bharatanatyam to Kathak, Odissi, Satriya, and other art forms. We also run another session called Discouraged, where we discuss the contemporary issues that dancers face. We have monthly sessions at Recognizing Dance, and the most important pillar of Recognizing Dance is the Scholar Series. We've had mostly scholars of dance at our platform so far, and this is the first time we are having a legal scholar, Geeta Ramaseshan here. We're very happy to have her amidst a really extremely busy schedule, and she's made out time for us for these especially for this discussion. Today we will be discussing the Madras Devadasis Act, passed in the year 1947 with Geeta Ramaseshan. And over to Aranyani. She'll take us through the discussion, and then we'll get into the questions.
Good evening, everyone. Good afternoon, rather. I just wanted to, actually, Maha said mostly everything that I wanted to say about the event. Essentially, what we're hoping to do, what we're hoping to achieve through this event is a deeper understanding of the act itself, because a lot of us have quoted this act in our research. A lot of us have heard about this act, but we don't all necessarily know exactly what the act says and what exactly, in legal terms, what that meant and what the implications of those of the provisions of the act were. So what we're hoping to do with Geeta is to go through the act provision by provision, and then we will also briefly touch upon the Madras Devadasis Association, their response to the act, their protest against it. And after that, following that, Maha and I will have just a few brief questions about the act and the events that surrounded it. And then we'll open it out for discussion for all of the participants here. So welcome.
Thank you.
Welcome, Geeta. So I think what we'll do is, so we've never had an event like this before where we've read through something at the event itself, and we're not diving straight into questions. So for those of you who have never read the act or who haven't ever come across it before, Maha and I and Geeta, we thought that we would just read one provision at a time and then kind of ask Geeta to respond. So Maha, do you want to start reading the act?
Sure. I'm reading it out right from the top. Okay.
Yeah.
Yeah. The Tamil Nadu Devadasis Prevention of Dedication Act, 1947, an act to prevent the dedication of women as Devadasis in the state of Tamil Nadu. Whereas the practice still prevails in certain parts of the state of Tamil Nadu of dedicating women as Devadasis to Hindu deities, idols, objects of worship, temples, and other religious institutions. And whereas such practice, however, ancient and pure in its origin, leads many women so dedicated to a life of prostitution. And whereas it is necessary to put an end to the practice, it is hereby enacted as follows. The first provision, the act may be called the Tamil Nadu Devadasi Prevention of Dedication Act, 1947. Yeah. I think that's up to the first.
Yeah. Actually, then this is what we call as the aims and objects of a law, where, it is set out as to what is the purpose of this law. Yeah. So what you read out was the aims and objects, and what actually, if you look at it, the way the aims and objects addresses this issue in terms of, while it addresses a practice of dedicating women as Devadasis, it doesn't describe what those practices are. That comes later. But it says that the practice, however ancient and pure, leads many women to dedicate it to a life of prostitution. So it comes to the aims and objects, describe it as a particular law which is required because women who practice this are often dedicated to a life of prostitution. We'll go into the nitty-gritty details, but I just want to say that this is what the Act's aim itself is, to prevent the law because women are going into prostitution.
Right, right. Okay. So the second provision,
Yeah.
it says, in this act, unless there is anything repugnant in the subject or context, A, dedication means the performance of any ceremony by whatever name called, by which a woman is dedicated to the service of a Hindu deity, idol, object of worship, temple, or other religious institution, and includes Pottukattu, Gajapuja, Mudri, and dancing by Kumbharati. B, Devadasi means any woman so dedicated, and C, woman means a female of any age.
Yeah, because I'm not so familiar with the forms of religious worship that this describes, in terms of Gaja Puja, Mudri, and dancing, etc. But I found that earlier on there was a discussion about the age. You see that in the earlier debates, whether any younger women alone who are dedicated, there should be a restraint dedicating young minor girls in today's language to be dedicated to this process also. But here it talks about female of any age. So it could range from 10 years to 60 years.
Right.
So it takes on that way. And then it describes the process of dedication to the service of a deity in a temple, idol, object of worship, or other religious institutions.
So that basically included anything that had any sort of religious association with it, not just a temple.
Yeah, because if you look at the definition, you see, if you look at and I'm sorry for our participants, whether it's actually a very small act, so it won't be very, very boring in that sense that we are going to go through every section. It's just to tell you that what it talks about is dedication, and then it says it includes. Okay. So it's not restricted to the custom of Pottukattu, Gaja Puja, Mudri, and dancing. It is inclusive. Okay. So all kinds of customs, including these customs, will apply to anyone of any age.
Okay.
So it's not just restricted to these customs only.
This is with reference to the earlier act, because the earlier act only prevented minors from being dedicated. So the 19...
Okay, maybe I because here it talks of any age. So
Okay.
here the as you see, the ends and objects is to say that it pushes women to a life of prostitution.
Okay.
And then it defines woman as a woman of any age, no restriction.
Okay. So the third section that I will be reading out, the dedication of woman as a Devadasi, whether before or after the commencement of this act, and whether she has consented to such a dedication or not, is hereby declared unlawful and void. And any woman so dedicated shall not thereby be deemed to have become incapable of entering into a valid marriage. Nothing contained in this subsection shall be deemed to affect the operation of the Section 34, the Madras Hindu Religious and Charitable Endowments Act, or the rights to which a Devadasi is entitled under that section. Can we split this? And
yeah, we'll split the first one because the subsection actually relates to the old law of the what we call as the HRNC law in terms of benefits, etc., made available to women under that act. Okay, because the earlier debates all talk about women having the right to some land and some of the properties, etc., that were in the that are the temple lands which should be given to them. So at the HRNC law deals completely with that. Okay, we can come to this at a much later point of time. But if you look at this here, see here there are two. There is one is it is what we term in law as a retrospective law. Okay, namely that normally, see, this is a kind of a law that has actually, when it talks about unlawful and void and things like that, it is actually criminalizing certain acts. Okay, criminalizing the acts of whatever is coming through in the previous section. Now, normally under any criminal law, it is what we term as prospective. Okay, it's always after the law comes into existence. It's never retrospective. I mean, if I were to give you a very small example, supposing tomorrow the government says, brings in a law, they're looking at such a law of that kind, that all marriages of people below 18 and 21 are unlawful. Supposing we bring a law like that. So far, there is no such law. It's only prohibited. Okay, it's not a law. But what happens if they bring in a law which say all marriages below 18 and 21 are unlawful? It cannot have a retrospective effect. It can't make all marriages before that particular cutoff date as unlawful. But here, the act is actually retrospective in nature, when it is actually prohibiting, declaring as unlawful, in that sense, making certain acts, criminalizing certain acts, because it says that before or after the commencement of this act, whether she has consented to such dedication. Now, if she has not consented to a dedication, then of course it's it's illegal and it's not at all. It has to be unlawful. But even if she has consented to such dedication, then in this particular instance also, the law is, the act is unlawful and void.
So, and does it also, just in very simple English, is it basically also saying that, I mean, it's basically saying that what you were talking about in terms of retrospective versus
Prospective.
Yeah.
Prospective.
That any of these, the Devadasi women, whether or not they agree to being dedicated or not, whatever it is that they practice, whether or not they were valid Devadasis or not, now, regardless of anything, even it's not just about the future, that it can be banned in the
past.
Yeah,
past.
Right.
Yeah, because the word is very clear. See, the dedication of a woman as a Devadasi, whether before or after the commencement of the act, whether she has consented or not consented,
right,
is declared null and void. But what they then say is that if a woman has been dedicated as a Devadasi, because the practice was that, I think, having been dedicated, you do not marry and have a marital life, so to speak. Yeah. So, however, what they say is that if you are dedicated as a Devadasi earlier, that if you marry someone else, if you marry a person, that will not be, and that is a valid marriage, because customary Hindu law, see, I'm actually going into different kinds of, see, Hindu law also is based on a lot of customs. So customary Hindu law did not permit a Devadasi to marry in the legal sense. Okay, she could have companion, but marry in the legal sense was not permitted, and therefore they have brought this rider saying, if a woman wants to marry, her marriage shall be considered legal, or if a woman marries, it shall be considered legal.
Yeah. Maha, do you want me to read our
Yeah.
next section? Actually, I did have another question about this, but I'll come back to it later. So the second part of this provision, any custom or usage prevailing in any Hindu community, such as Bogam, Kalavantula, Sani, Nagavasulu, Devadasi, and Kurmapulu, that a woman of that community who gives or takes part in any melam, within brackets, notch, dancing or music performance in the course of any procession or otherwise, is therefore regarded as having adopted a life of prostitution and becomes incapable of entering into a valid marriage. And the performance of any ceremony or act in accordance with any such custom or usage, whether before or after the commencement of this act, and whether the woman concerned has consented to such a performance or not, are hereby declared unlawful and void.
Yeah. So this is exactly what I was telling you earlier, that customary practice, which is a source of law, it's always considered to be a source of law. For example, the recent customary practice, big debates on whether women can enter the Sabarimala temple. People were arguing, those who did not want women to enter the temple were arguing on the basis of customary practice of the temple. So therefore, custom is always accepted as a source of law. Okay, except today we have, of course, come much ahead in the way we interpret it in the context of constitutional rights. So any custom that is violative of a constitutional right is considered to be null and void. Here, what they are saying is that if there is a custom in any of the various Hindu communities, okay, where a woman who is a participant in a melam, dancing or music performance in the course of any procession or otherwise, within the customary practice or of those, within the customary practice, it was considered as per this act. I do not know. I mean, I'm not a sociological scholar. I've not done that. I don't have that knowledge. But to understand this particular section, it is just to say that if, for example, women are from these communities, or if they have participated, or in these Hindu communities where if a woman participates in the forms of dance, etc., described, as per the community customary practice, if she's considered a prostitute, that is, and therefore incapable of having a valid marriage, that particular custom is wrong, and that particular custom is unlawful. I don't know whether I spoke too much in a legal way. Just to say that, women who participated in those forms were within certain communities not found fit to marry and were termed as prostitutes. So that particular custom, it was a customary practice, and custom is always a source of law. Customary practice was considered to be invalid. I mean, I know customary law may sound very, complex for you, but just to give one small customary practice in almost all, in many Hindu communities, let's say, is the Saptapadi or walking around the Havan. These are all customs. Yeah. So when, for example, in a litigation, a man comes and says, I never married her, the wife will bring in evidence to show that, yes, there are photographs to show that we had this form of marriage. That's the best example of a custom I can give you, a simplest example of custom I can give you to make this provision more understandable.
Right. So just to ask you a question here about between the first part of this section and the second part of the section, where the first part it says,
you shall not consider a woman of having adopted a life of prostitution if you have been a dancer, if you have been doing a musical performance or a melam, etc., in any procession. That's the meaning in the first line.
Right. No, but what I was saying was that, like in that provision 3.1, it says any woman so dedicated shall not thereby be deemed to have become incapable of entering a valid marriage. So, and
Yeah, no, it says you're capable of.
yeah, so it says you're capable of entering into a valid marriage, but then in the second part it says if you continue to do these things, then you will not be, because then,
Yeah, that's a bit of a contradiction here, you know. What
yeah,
it says is that if you, no, it doesn't contradict. See, it doesn't contradict itself. First, it says that you're free to marry. No custom can say that you cannot marry.
right,
Okay. So if a custom says something like that, that is wrong. That doesn't say what kind of action is required, but it says it is wrong. Here it says that within certain communities, it mentions certain communities. Here it says within certain communities, since it was probably a custom to term a woman who was dancing, you know, who was singing, dancing, etc., as a prostitute. That custom, and based on that custom, nobody would therefore, you know, she was not capable of marriage under the law, under the customary law. They say that such kind of customary laws are not valid,
okay,
are unlawful.
okay, okay, okay.
So basically saying that in a very simplistic way, to say that you have a right to marry, you know, and that marriage is legal.
Okay. So
More
both
than anything else. Yeah.
are
Because the
based,
customary practice, see, the customary practice of Devadasi dedication was getting married to the
deity.
god or the idol, right?
Yeah.
Therefore, you could not get married again. Here you are free to marry, merely because you are born as a Devdasi or you have participated in dance as a form. No one can say that you cannot marry again.
Okay, okay.
Okay. So the next section within this provision is dancing by a woman with or without Kumbharati in the presence of the temple or other religious institution or in any procession of a Hindu deity, idol, object of worship installed in such a temple or institution or at any festival or ceremony held in respect of such a deity, idol, or object of worship is hereby declared unlawful.
Yeah, here it talks about here it talks about dance. Okay, earlier on it was about you know, and here again, if you look at the definition of woman, even a 60-year-old woman, a very senior citizen who is a dancer, any kind of a dance is considered as immoral.
Right.
And before the temple, I mean, you know, if you have read out the act, so I don't want to. So in any procession or a temple or before an idol or before an object of worship installed, etc. So the what do you call, the act of dancing in a temple is immoral.
Okay.
Okay.
And
Act of dancing by a woman.
right. And in the previous section where it talks about any melam or dancing or music performance in the course of any procession or otherwise, so there they're talking about something broader than what they're talking about in section 3, right?
No, there I see there you have to look into the fact that what it talks about is that there is a community, there is a definition of certain communities. Okay. Presumably, I'm reading the section alone. I have no knowledge of customary of community practices at that time within these communities. So what they say is that women of such community, when they were participating in melam, music, dance, etc., or giving any performance, were considered to have adopted a life of prostitution and became incapable of entering into a valid marriage. So here, whether the woman is into prostitution or not, the fact that she was doing these forms of art gave her made her a prostitute within those communities. Okay, she didn't have to be one. See, she didn't have to be one, but I mean, for me, it's also being so much using the term prostitution itself is very difficult for me, because the term now is something else, sex work. But be that as it may, for those times, if you were in the art, you were considered as a prostitute as per the custom of that community. Here the question is custom or usage. Please remember, it's very different from one family considering you or the village considering you as a prostitute. There was a custom or a usage that said that if women participated in certain acts, they were prostitutes. That's a custom, irrespective of what they were. So here it says that particular custom is totally invalid. That particular custom is unlawful.
Okay. Right. Okay.
The language of law is always very much like the scriptures, making it very hard for people to understand, except for lawyers and those who can, make use of it in various ways.
Yes, well, that's why we have you here to explain it to us. All right, should we move to the fourth provision?
Yeah.
So the first part of that is any person having attained the age of 16 years who after the commencement of this act performs, permits, takes part in or abets the performance of any ceremony or act for dedicating a woman as a Devadasi, or any ceremony or act of the nature referred to in section 2, section 3, subsection 2, shall be punishable with simple imprisonment for a term which may extend to 6 months, or with a fine which may extend to 500 rupees, or with both. And the explanation they've given here is the person referred to in this section shall include the woman in respect of whom such a ceremony or act is performed.
Yeah, basically, here the act talks about permitting somebody above 16, 16 at that. So above 16, if a woman permits somebody to do this particular act, okay, to do any particular form of dance. So say, for example, your daughter or your sister or anyone, okay, if you're above 16 and you bring someone else into the form, okay, that form is of two kinds. The form is, of course, permitting the person to take part in, which could be a family member who permits their daughter to take part in. Now, abetting the performance of any ceremony or act. Abettment is a very criminal law term. It means that I facilitate and assist. Of course, it has a much stronger terminology in criminal law, but the best way I can explain that to to all of us is that I am assisting. So say, for example, the mother wants to dedicate, okay? She takes the help of another person, maybe another Devadasi. She takes the help of a priest, or she takes anybody's help. Those two, the other person, are considered as abetment. They are abetting the act. Okay. So here now what you consider is that permitting a person to perform, that's one type of people. Could also be the temple authorities. They are permitting a person above 16 to perform. It's huge. The interpretation of that can be very huge. It's a very wide umbrella under which different categories of people can be brought in. Abetment is where you facilitate, like the two examples I gave. Okay. Then, so anybody who abets the performance of any permits, takes part in, or abets the performance of any ceremony or act for dedicating a woman as defined earlier, which we saw, in as defined earlier, that is in with reference to the ceremonies, with reference to customary practice, as defined earlier, that is with or without. In section 3, it talks about in any temple or other religious institution, in any procession, etc. It talks about the previous section. Okay. So as defined earlier in the previous section, are committing an offense and are liable for punishment. So that therefore, you can now see how it has criminalized the act of the issue of Devdasi. Because first you are saying it either before or after. Anything done before or after is unlawful. Okay. So there's a complete ban. That's a complete total ban. But taking the past acts as unlawful, it has gone retrospective. Then you say, then there is no age. Okay. Women of any age can be committing an offense in this. Because let's say a very older woman who goes to dance in the temple, she's committing an offense. So therefore there is the act of offense which can be committed by the individual dancer, or where even if any young, here it is 16 is a young girl, but anyone above 16 performs, takes part in, or abets the conduct or ceremony in any manner are committing an offense. And here it actually goes a little more. See, it talks about takes part in or abets the performance or any ceremony associated with the
deity. Or
yeah. So it can be any kind of a ritual or a ceremony that was done. So will also be a abettor. Huh?
Would that include like a ceremony in their own home also?
Yeah, because it talks about ceremony or act of the nature referred to in section 3. Subsection 3 refers only to precincts of temple or other religious institution.
Okay.
Doesn't talk about home.
And also just another clarification, because it says Madras Devadasis Prevention of Dedication Act. Here in 1947, we're talking about the Madras Presidency, right? Not Tamil Nadu.
Yeah.
It includes.
Yeah.
It includes.
Yeah. The big presidency of Madras.
This is why the act includes Kalavantulu, Bhogam, Sani. In fact, all the names that we read out initially are
section 3.
The hereditary singer practitioners from the Telugu region. Currently Telugu region.
Yeah, it is a Madras Act for the entire Madras presidency up to bordering Berhampur, I think. Orissa was also, parts of Orissa were part of Madras Act.
So this covered the Maharis as well, probably.
Yeah.
I know, not full of Orissa. Berhampur.
Okay. The next subsection is any person having attained the age of 16 years who dances in contravention of the provisions of section 3, subsection 3, or who abets dancing in contravention of the said provisions shall be punishable with, we've already done that, right?
Yeah, no, here there are two issues here. This is an additional, you see, it's very, you look at the explanation. See, the first point says that having attained the age of 16, okay, after the commencement of this law, performs, permits, takes part in, or abets the performance of any act, okay, for dedication of the woman as a Devdasi in any ceremony. Okay, that's the first half. Now, that is a minimum punishment of simple imprisonment of whatever. Terms of punishment really don't matter. But after that, if you look at the explanation, the person referred to in this section shall include the woman in respect of whom such ceremony or act is performed. So let's say for a 17-year-old, a particular act and the act is performed, then she also is, theoretically under this law, she can also be a person who has committed the offense and is liable for punishment. Now, the second part that you read out now refers to the act of dancing. It talks about dancing. Okay, the first part relates to the rituals and ceremonies, etc. The second part relates to dancing. Dancing, again, in the same manner, it says that anybody who has attained 16 years, who dances in contravention of law, same language again, who abets dancing in contravention of the said provisions, the punishment is higher.
Okay.
6 months. So musicians, singers, anyone who would accompany an artist will also be liable for punishment. So there is the issue of performance. First is the issue of sermon.
Okay. The last section, Aranini?
It's just one sentence. It basically just concludes the act by saying no court inferior.
No, that's not so relevant. That only talks about which court will try the offense.
Right.
That has no relevance now.
Okay. So yeah, so basically, so that's the gist of the.
A very small act, right?
Yeah, it's a
very small act. Maybe there would have been rules, I don't know, but I was also not able to find them. It's a very small act.
Okay.
Yeah. So I think the next thing that we wanted to really talk to you about was maybe a few sections of the response by the Madras Devadasi Association.
Of course. Okay.
So I think we'll just dive straight into it. Maha, do you have that file open?
I do.
Okay.
Yeah. So before that, I just want to tell you, as per the scheme of this act, it is unlawful. It is retrospective. It criminalizes the act. And once everything is unlawful, there is also a trickle down effect. Because if anything is done unlawful, then you cannot have anything under that law. So say, for example, your earnings, I mean, that's the whole issue, right? So your earnings actually can become sullified. If you actually, in today's context, if you look at anything, you take a crime that is committed, unlawful proceeds.
All right.
No one has a right to them. Here, somehow they have exempted that. But whether that was in some cases, I don't know. So that's unlawful. And it essentially, I think, cripples a person's livelihood and makes every woman who is a Devadasi as a prostitute. I mean, it generalizes in a very big manner.
Right. And actually, it's the fact that you said this sentence actually is where we are going to be starting talking about the response, the Madras Devadasi Association's response. I'll just quickly read just the beginning part, and actually, I think we should also talk. I'm going to go through the first page. Is that okay, Maha?
Sure. I mean, I think everybody should listen to the response of the Devadasis as well. Right? At least we should. I just go ahead.
Yeah, because it's generalized everybody.
Yeah, so
it's generalized everyone in one sweep.
So we won't go through every single word, but we'll just go through what the three of us just decided to.
What was important.
Yeah, what was important and kind of very directly relevant to the act itself. So the humble memorial of the Devadasis of the Presidency of Madras most respectfully showeth point number 1, Dr. Mutulakshmi Reddy's resolution. Dr. S. Mutulakshmi Reddy of the Madras Legislative Council brought a resolution in our Legislative Council which reads thus as amended. This council recommends to the government to undertake legislation at a very early date to put a stop to the practice of dedicating young girls and women to Hindu temples, which has generally resulted in exposing them to an immoral life. This recommendation was moved on 5-11-27 and accepted by the local legislative council. Point number 2, our protest against it. We most emphatically raise our voice of protest against the resolution and against any attempt at legislation which has for its object the stopping or prevention in any measure whatsoever of the dedication of young girls and young women to Hindu temples. We shall firstly deal with the ostensible objects of this resolution and of any legislation which may be brought to fulfill the spirit of this resolution, and show how the objects of the legislators cannot be fulfilled by the proposed legislation, and how the legislation would bring results just the reverse of what is intended. And we shall then specify our specific reasons for not allowing any such contemplated legislation to be taken up. The next point, they just dive right into it. The next point is Devadasis are not prostitutes. The first and foremost and the only object of the proposed legislation is that such a dedication of Hindu girls and women generally resulted in exposing them to an immoral life. This sympathizes with the future of our womanhood and is generally against an immoral life. Let us calmly analyze the implications of this idea of legislation. The community which dedicates their women to temple service is known as Devadasis. It is a compound of two words, God and devotee. Wait, I'll just skip through this a little bit because it's just going over very basic things. Popularly, our caste is styled by the name of dancing girls, probably due to the reason that most of our caste women are experts in dancing and music. So then she says, such a name is unfortunately mingled up and associated with an immoral life. It would, we submit, be easily conceded by everyone that the institution of dedicating one's life to a temple has nothing to do with prostitution. This is not merely our own self-glorified opinion, but a considered judgment of some eminent judges. And then they go on to give a couple of names: Mr. Justice Mutulakshmi Iyer. The observation is accepted and reiterated by another judge, Parker J. And then another judge, learned judge, Mr. Justice Subramana Iyer, is also said to say, it is scarcely necessary to say that neither in theory nor in practice is the dedication to the temple looked upon as an essential to a woman of the dancing girl caste becoming a prostitute. So yeah, that's basically what they're saying. We humbly state that we cannot add anything to the above remarks of the illustrious judges. In spite of this, a sad confusion of thought arises, and we submit that this confusion of thought underlies the object of this resolution. Hence, we make bold to question the implied identification of Devadasis with prostitutes. Geeta, would you like to?
Yeah, actually, I mean, may I read a little more on that? They also say that there is an immediate and clear connection between the ceremony of tying the puttu and the mirasi office of a dancer claimed in the case, inasmuch as the former is a necessary preliminary to his entering upon the duties of that office and to her enjoying the emoluments attached thereof. This is why the link to the temple in the terms of getting certain amount of not property, but some of the benefits that the temple accrues to the girl.
Okay.
Yeah. So, I mean, you look at it the first sentence itself, they forget the fact when they say that Devadasis are not prostitutes. The act actually tars everyone with the same brush and holds women of the Devadasi community, it just stars them and says they are all prostitutes. I mean, that's the implication of the law, even though they say if there is a customary practice this way, if there is nothing like that, you have a right to marry and that marriage will not be illegal. It just stars everyone that way.
Right. Okay. So, Maha, do you want to read the fourth part? You're on mute.
I think the fourth point is very important here, because they say prostitution as such may be suppressed. If the object of the measure is to suppress prostitution, why not check prostitution where it is found and by whomsoever it is committed? Why should anyone deal with Devadasis for that? We have to state that prostitutes come from all classes of society and prostitution is an incident of social influences. It's a small paragraph. I think it's important to read this out. I'll just, yeah. We need not here analyze the underlying motives of prostitution. Prostitutes are a low class of people who degrade themselves by the immoral conduct and are consequently unfit to mix with society. They are found among all castes and creeds. We are given to understand that prostitution as such is not an offense in India, and we can have no objection to any measure, however severe it may be, to check prostitution. We welcome such a measure because if an act is passed preventing prostitution, the few of our members who have erred would become rectified. If some of our members have gone astray from the path of virtue, is the whole community to suffer? Similarly, as prostitutes are found amongst all castes and creeds, it would follow that all castes and creeds should be condemned for the sins of few. This we would submit, and you would certainly agree with us, is neither logic nor justice.
Yeah, so here the Devadasis identify themselves as a separate class. Different classes are actually today protected under the Constitution. So you're identified as a separate class based on your community caste status. Okay. Now, and it is true that at that point of time, there was no law that actually made prostitution an offense. What you see in this act, in my opinion, is that while holding that this has encouraged young women to be forced into, who are then made to be prostitutes, as the aims and objects say, it tarnishes the women alone as prostitutes. The aims and objects talk about, now what does it say? Yeah, the aims and objects say that a dedication of women to all these has led to a life of prostitution. That's what it says in the beginning, right? So but what does it do? It says any woman who's Devadasi from now on, literally, is prohibited from being so.
Right.
And there was no law. It is true that there was no law that actually addressed the issue of prostitution in India at that point of time. It came much later.
Yeah, and Maha and I were trying to do a little bit of research on this, and we haven't been able to find a clear answer on whether, prostitution is legal in India at the moment.
No, it's not. No, it's not legal. The woman is not punished.
Right. Yeah, soliciting is illegal.
On the soliciting in public.
Right. Yeah, it's very vague. Like, we couldn't find a clear answer to
this. It's not legal, and there's a big debate about how it should be decriminalized, and or whether it should be legalized. We're still at that stage. We are at the decriminalizing stage.
Okay.
I mean, that's again come because of a strong, sex workers in many parts of the country have organized themselves, and they are participating in all the cases that have come up before the Supreme Court. They are in various committees, etc.
Right. Okay.
I once again want to reiterate that the response that we are reading is a response of the 1927 legislation. However, the act that was passed that we initially read out was in 1947. However, we wanted the representation of the women also to be discussed today, and hence we are discussing. However, these are
not one after the other.
Yeah, one after the other. Yeah.
Okay. Yeah. Okay. So then the next point, the next part of this that they talk about is the real purpose of our caste is religion and service. And what they basically say is that that the real object of our caste is to dedicate oneself to a life of religion and service. Who can object to this? We were associated with various temples and mutts throughout the length and breadth of our presidency. And our institution is similar to the institution of mutts presided by sannyasis for the propagation of religion. So this is so we submit that this is the object and the main purpose of our ancient institution.
I found that very interesting. That they consider themselves highly independent, And they see their roles like that of sannyasis, who, in terms of their dedication to God.
Yeah. Maha, do you want to read the ninth point?
Okay. The ninth point is whole community cannot be condemned for the sins of a few. Let us be permitted to also point out that any legislation abolishing dedication to God affects our freedom and freedom of conscience and freedom to follow our own religious ideals. In proposing this legislation, they attempt to do away with forever with our sect. Assuming without conceding that a few of our community have gone astray, why should the whole class be condemned to a practical annihilation of itself? We like to expect cold logic in all its various aspects. If a single member of a family goes astray, should the entire family be ordered to be extinguished or be given injunction not to procreate itself, lest another erring member be born? If a member say of one class misbehaves, should the whole class be condemned forever? Such legislation is unheard of in any civilized world. Not even in the fines imposed on the Anglo-Saxon family for the thefts committed by one of its members is any parallel to this proposed legislation. In an attempt to annihilate a whole class, recalls to our mind the mad frenzy of French Revolution and the barbarous outbursts of modern Russian innovator, not legislator. Yeah, that's about the gist of the provision. Do you want to respond to it, Geeta?
No, I think it speaks for itself, no, where it just talks about how can you see, this is the whole thing. How can you tarnish an entire community if certain acts are done by a few? Put it like that. How can you bring in a legislation for an entire community if some do certain acts? We are seeing the debate still today on other issues.
Yeah. Reddy, you have to unmute.
Yeah. Sorry. The next point that they make, the Devadasi Association makes, is our right to live. We base our claim to live as a class upon our past, upon our utility to other classes in the life of the nation today, and in the immense possibilities of our usefulness to the Commonwealth in the near and distant future. Then they talk about accounts given. They've quoted from the writings of Dr. Annie Besant, and our class is mentioned in all of the works of literature and religion of our country throughout its various epochs, and goes into even, they even quote the Vedas and all of that. We are doing our customary, and they end by saying we are doing our customary services in the temples and mutts, and thus form an integral part of the religious life of the nation. In the future, we believe that we shall strive our best to the advantages of a free and compulsory education, which we pray that the legislature may bestow, to achieve the ideals of our past and lead the sacred life described in the preceding part of our memorial.
Yeah, I mean, here you find the representation talking about their achievements, right? What women have achieved, what they see their work as, but more than our right to live, which is, it's also closely linked to the right to livelihood. So you're taking away, their representation talks about taking away our right to do the thing we know best.
Right.
We are pioneers of the art. You are taking away literally our way of life. You're taking away literally, which means our right to live. In the process, you are also actually going to take away the right to livelihood.
Right.
The right to earn, the right to be independent, the right to have self-determination, all of which many women had. Actually, if you look at it that way, I mean, I would look at it in a very different way. Almost all of them were strong women who had partners, maybe, who did not have partners, but who were single, who brought up their families and who were supportive of an art form. At least that's the impression I get reading the representation in its entirety.
Right.
All right. Yeah, we had another question. Arun, do you want to go through the response, or can we move to the question?
I think, okay, I'll just, instead of us reading the entire thing, I'll just quickly go through just so that everybody gets a clear picture
The
of
11 points. Yeah.
just very, very quickly.
Yeah.
So after they talk about their right to live, then there are some points about their our right to property affected. Even though the act does say that it won't be affected, they did seem to be, or maybe it was a response to this. But they've said here, what is to become of these lands? We believe that these lands will be taken away from us.
Yeah.
Any attempt at protection is inconceivable. Then they go on and will have very dangerous results to the community. No one would think of annexing lands of a family because someone of the member offended the ethical conscience of the public, etc., etc. The next point, which I thought was also very important, was that that they felt that this legislation increases the tendency to prostitution, because such an interference with our inams would deprive us of the honorable source of living. And if we are turned to paupers, prostitution is certain to invite some of us, and they may fall prey to it. And one of the main reasons for prostitution is poverty, and why should we be turned out as destitutes? Then it goes on to kind of points about gradual evolution, legislation, public support to legislation, and then it talks about they make an appeal to the press and the public. And this I thought was an important thing as well. Our great need is education. Having considered our case, oh, it's a very long paragraph, but they talk about what they need is education, and what they'd like to have is education. And finally, they end with an appeal for justice, and they say, finally, we beg to close this appeal to you, to not to pass any legislation suppressing or interfering in any manner whatsoever with our dedicating ourselves to a life of religion and service. Please consider our great past and the ever bright future. Do not be blinded away by prejudice and personalities. In trying to mend an evil, do not end an institution. Remember that every nation is a body politic, that every nation has one life, that neglect of one part injures all. Give us our birthright to live and work for the cause of our country. Give us encourage and foster our ideals of love and religion and service, and our arts of music and dancing. We are the modern descendants of those who in the past held aloft the torch of civilization. Do not mistake the opinions of the few interested champions for public opinion. You who stood for religion, toleration, and freedom of religious and philosophical opinions in the past, you who boast of your tender love for small communities, we pray that you may allow us to live and work out our salvation and manifest ourselves in the dual aspect of wisdom and devotion, jnana and bhakti, and show to the world both the aspects of spirituality and the noblest religion enshrined in the sublimest philosophy, and that we keep alight the torch of India's religion amidst the fogs and storms of increasing materialism, and interpret this message of India to the nations of the world. We beg to remain your most obedient servants, the members of the deputation of the Devadasis of the presidencies of Madras.
Yeah. Oh, that was long. Anyway, yeah, I had a question for Geeta. My question was, what prompted the 1980 Act, and what was the 1980 Act about? Can you give us?
88, you mean?
88, is it? Yeah.
Yeah, well, actually, the 88 Act came because there was a large amount of, there was initially a big exposure. Everybody came through about, we also, about dedication of young girls to various temples, not temples, very small temples in Andhra, in the borderline of Andhra, Karnataka, etc. And from there, it was found that the young girls were forced into prostitution and then were sent to Bombay. There have been studies in that regard in that area, and families who were very poor were actually giving their daughters to be dedicated in these temples in return of money. So as a response to that, because it was a huge issue. As a response to that, they brought the 1988 legislation in Karnataka and Andhra. But the language of that legislation is actually very similar to this. It talks in the same manner. However, it makes it a very strong, takes on a strong role with reference to punishing those who are indulging in this, because there were certain studies, and there were indications that this was actually going on into a trafficking route to Bombay. So 88 came with a different response. They were not performing in temples or anything of that sort. They were just brought before the priest who did the Pottu ceremony, etc. And then after that, the young girl was sexually assaulted by the priest or by others and then sent off to Bombay. That was the reason why that particular act came.
Okay. Geeta, we wanted to just ask, I know where we do want to open this out for interaction with all the participants present here, but we just quickly wanted to ask you just very very if you could, this one might have a very simple answer. Is there a possibility of a judicial review of this law?
I don't know. You mean challenging the constitutional validity of the law? You'll have to come up with a very sound case, as to how. I have not thought on those lines actually. Because of course, under the constitution, any law that is even before independence, if there is any legislation before independence, it has to stand the test of the constitutional rights. Right. That is a general provision. So in terms of challenging it, one will have to then, if one wants to go back to, if one were to go back to, if you were to say that you want to, you have to challenge it by saying that you would want to be a performer, you want to start, you want to be a dancer, you come from these traditional communities, etc. But I don't know how.
But
theoretically, yes, you can challenge.
Right. So theoretically, it's possible.
Yeah, but practically, I don't know how it will frame itself out. I've never really thought on those lines, so I really don't want to say anything about that.
Right. Okay. I mean, this is a question that we'd gladly open out for the wider discussion as well. Maha, do you want to ask
we have one last question. What could be the role of the state in rehabilitating women from these communities and bringing dance back to them?
I don't know. I mean, are there anybody who are identified who are there? What the question of role of, even if you look at this law, it doesn't talk about anything. It's very strangely enough, while this law just criminalizes the Devadasi way of life. You find you find that it does not talk anything about what has to be done for women. And when here in this representation, they talk of property. And in the HRNC Act amendment was to give women their rights as per their share, but not all temples and not all women had inheritance in terms of property from temples. Okay, not inheritance, grants, etc. from temples. Now, the second point is that I mean, it depends upon people coming and asking the state, no? You make a demand to the state, then we can see how that response can be done.
Right. So I mean, it would have to come from the people.
Yeah. Otherwise, the state is not going to identify anybody at any point of time.
Right.
They are well with among us.
Yeah, they have, but we know how systems work. But maybe if there is a demand, you identify.
Right. We'd like to now open this out to for discussion. I just wanted to also mention that Akshaya Sukumar is here. She has written. She has a master's in sociology from Loyola College, Chennai, and conducted research and submitted a dissertation on the topic of sociological analysis on prevalence of Devadasi systems in SIVLLR community and its changing trends in Tamil Nadu. Akshaya, would you like to say anything about how what your research kind of brought out in terms of?
Here, though, I thought I did see her.
Yeah, she was here. I don't know if she still is.
No, she isn't here right now.
Oh, okay.
But I would also like to acknowledge the presence of Vaishnavi and Dr. Yashoda Thakur, who are also women from this community. And before we open it out to questions, if they want to comment and if they wish to comment, they're free to add, because they have been, they are the members of this community. But otherwise, we're happy to take questions. Okay, any questions? Or Yashoda, okay, Vaishnavi wants to speak. She's on.
Yes. Where are you, Vaishnavi?
I thought she unmuted. Vaishnavi, Nature Connections is Vaishnavi.
Ah, right. Well, yes. Well, at any point of time, if anybody wants to, say anything.
Okay, I added Yashodaka. Do you want to say something?
Can I respond, ma'am, Yashoda? Because yes, I made a mistake. That is why I said it was grant, not property.
Ah, right.
You had said that. I corrected myself earlier. I mean, this when they are, it was just what they were getting, the benefits, etc., that they were getting from the temple. There was, of course, no property.
Right. Okay. Yeah. Okay. Well, I wanted to ask about whether there's a way. I mean, why did they?
But Yashoda, sorry, Aranya, but Yashoda, you had a very interesting point on the 1988 law. Could you add a little on that?
So, ma'am, there is one of our relatives who keeps harping on me. He keeps calling and saying, it's not amongst your dance and your academicians that they should be, this change comes in. And I keep telling him, Baba, we do talk. Today, Kalavantulu is spoken about. It's not like in your time. Everybody talks about it openly. Things are changing. Society is changing. But he says, no, that's not enough. Get a paper from the government. This government in 1988 put everybody in the same bracket, I personally have no problem with that. But then for them, it was a big thing because it was needed that they are the chaste Devadasis, the divine Devadasi family. So he said, get a paper from the government saying, we, the Kalavantulu, are not the same as the Joginis and the Matangis and others. So that's how I know that it was added later, because he told me this. Just wanted to say that.
So is there a way that could be challenged? You could think you could challenge this debate. It requires a lot of work, but I think now that when the Supreme Court is going so much and there's so much discussion on sex work, etc., why should not forms of art be denigrated this way?
Yes. So the difference between them and the Devadasis, as the name came later, and even they are under the term of Devadasis, so it's a little confusing. The difference is just that we do the music and dance, and they don't. They don't do the music and dance. We are all temple women, though. We are all connected to the temple in our own way. It's just the economy of the temples that we are connected with is different. These Devadasis are connected to large temples, and they are connected to the smaller indigenous temples. And the way they are, it is the head of the village who has a power over that lady there too. Except for the art, which is a big difference. There is the art difference. Generally, it is the same. It's just that their lifestyle is not glorified, whereas this lifestyle is glorified. That's what I understand. And it's very sad. When you actually look at the Joginis and the Matangis, man, your heart goes out to them. It's very sad. And if it works, I think somebody has to take it up. But having said that, we don't want to do the same thing that has been done with the Devadasis, no, ma'am, where the act comes and they're all struck off in one stroke, and they're not given another option. They're not given another solution. I would say let the tradition be, but educate them and give them a choice whether they want to go for it or do something else. Today, if I take off the patronage or even the oppression, let us say oppression of the head of the village, the 2 meals that they get in the day also will not be there. They may not be oppressed by the head of the village, but they won't have any food either. That's what happened to these women here, right? This has to be done very carefully. That's the thunder. This has to be
Yeah,
done.
I think when we talk so much of choice today,
Yeah.
The right for a woman to be, constitutionally my choice, etc., etc., etc. I think this is the exploitation or crime by men should be clearly
Yes.
distinguished from the right of the woman to do what she wants.
Yes. For all you know, she may want to continue that. How do you know?
Why not? I mean,
Yeah.
what is wrong?
Yeah, what's wrong?
Exactly. Like the Devadasis wanted to. It's the men of the families who didn't want them to.
Yes.
Yeah.
Because they were gaining.
They were gaining, ma'am, and even the land was not on their name from the temple. They just enjoyed the produce of it.
That's what.
So,
that's why the grant is how I said instead of the land.
yes.
Yeah.
Yes. So once the act came in, the land became open for everybody, and quickly the men took it. Anyway.
So Akka, Yashoda Akka, I actually wanted to ask what do you feel like? I mean, when I was reading the response, or whether I was reading the response to the 1927 legislation, or whether I was reading the act, one of the things that kept resurfacing in my mind was, why couldn't the legislators or the people that were spearheading these kind of reforms? I mean, of course, there's no doubt that the dedication of minors, particularly if it was without their consent, is a very deeply problematic practice. But why could nobody be able to make that distinction between? I mean, I'm asking this question to both of you, Yashodaka, as well as Geeta, as well as anybody else who might like to speak during this open interaction. Why couldn't they make that distinction between the dancing and the other practices, or the dancing and the religious ritual, or like there are various aspects and various different things. I mean, we keep talking about this whole problem of homogenizing.
No, but that was done by design, no, Aranyan. That was done so that these women are not there, but the dance can be taken and it can be planted elsewhere. It was a very strategic process. So if you notice, there is not so much dancing, reference to the dancing in the act itself.
Nothing.
Nothing at all. So they only talk about the character of these women or what has to be done to them. So it was.
But that's precisely why I'm confused about why then could that. I mean, you're saying, so Yashodaka, what you're saying is that there was a design to actually, a deliberate design to take the dance form and place it elsewhere.
Yeah. So Mutulakshmi Reddy's argument is that by then itself, the lifestyle of the women was very degraded, whatever that means, or they were suffering a lot. And has the act done any good to them after that? So many years later, we come, my family and my family, from my father's family onwards, that's the generation that we are educated and in the mainstream. We believe that we are assimilated into the mainstream. My extended family believes very strongly that nobody knows their caste. Nobody talks about their caste because they're all very rich and they're all very highly placed. Whereas I know that everybody knows and everybody talks behind, which is not their problem. So what was the question? I just got strayed away a little bit.
Why couldn't they make a differentiation between the dancing, like the performing arts aspect of it, and the dedication aspect of it? I mean, this whole thing is called prevention of dedication. So why couldn't they have prevented the dedication of minors, or the forceful dedication of minors, but without letting without taking the dance form and the livelihood away from the.
Livelihood goes with the dance, no,
So
Aranyani.
that's
Once
what
there is no temple, because the temple was a very important place. Much as we say today, no religion and all that, the temple was a cultural spot. That's where business, economy, activity, everything, politics
Yes,
also
that's
is
where
there.
I'm going, Akka. That's what I'm asking. Like, why couldn't the dedication be stopped, but the dancing be still allowed in the temple?
But that was the idea, that they don't dance, somebody else dances, because by they were trying to brand them and stamp them, because an unmarried woman was very difficult to take. The position of an unmarried woman is equal to the whore. So already the mindset is completely colonized, right? So you cannot understand the existence of an unmarried woman living a wealthy life, a respectable life. So the woman had to be hit upon. And if that is her strength, we don't talk about the strength.
She was calling the shots, right? So
yes, she was calling the shots.
Yeah.
Also, if you look at the act, there was so much talk about how women should have, they must be taken care of, so to speak, okay?
Yes.
But there's nothing in the law except criminalizing it. There's nothing in the law as to what is the support system. Supposing a woman flees, where will she go? Nothing at all.
Yes. So that's what I was saying when I said, if we do something for the Yoginis today, we must make sure the same thing is not done to them again.
Yeah. I
So
mean,
at
I
least
think
now.
this is also something that Dr. Amrit Srinivasan has said, right? That, I mean, we have that this act and this whole legislation was supposed to have ended dancing in temples, ended prostitution, ended dedication, but dedication continues, prostitution continues, dancing in temple also continues. The only people that seem to have suffered in this whole thing are the women, are the hereditary dancer women. Whereas the reasons for why this act was passed and this legislation was passed, all those reasons seem to still exist. It's quite an interesting statement to make.
I won't say the reasons exist. Prostitution, sex work exists at a different category. Apart from that, none of the reasons exist. So actually, I would definitely agree with Ms. Yashoda about how, you just killed an art, or you just killed a section of people performing their art, career by today's words, their skills, their everything.
Yeah.
And in the process, you also stop them from making any livelihood. There's nothing in this act about livelihood issues.
So you were talking about the strength. I'll just put it, and I'll tell you the humor side of it, ma'am. You were talking about the strength of these women. So when my teacher, Anna Batula Mangata, teaches, and that's the thunder, you have to listen to it. When she was teaching me one Javali called Poti Talagaleni. And in that, there is a movement where the man is, he's standing there and he asked me, he folded his arms and asked me to give him a kiss. I said, no, no. And he came and gave me a kiss. And then there's a movement where she covers her breasts and goes, she did that. And then she said, no, no, don't do it, because today's audience will not understand it. They will not appreciate it. I said, no, Amma, you don't change for today's audience. You teach me what you do. And she said, no, no, at my time, the audience were very different. Today's audience don't have the taste, It's their loss, is what she said. So when she says it's their loss, there is so much strength when she says they can't enjoy it, we will not do it for them. That kind of, just to give you the nicer side of it.
Thank you so much, Yashoda.
I have just one last question before I know you really have to go. But I just had one question, because the men in the dynamics of the Tamil land and the Telugu land and the community in Kalavanthulu had a very different role. But whereas in the 1947 Act, as we see it in Tamil Nadu and the Madras Presidency, the self-respect movement is deeply tied into the act. So what happens? Is it the same in the Telugu country, in the Telugu land as well, with respect to the men and their role?
Maha, in the Telugu land with Kalavantulu, the men did not do the Natvangam. The conducting of the program is still done by, even today, Amma does it. There is no man. It's done by the women, and it is done by the lady, Melam, the leader of the Melam. Okay, and but the men did learn the art. This is, initially I thought all of them left it, but men learned the violin, men learned the mridangam, and they were always accompanying the main lady, the Nayukra. They were accompanying her. So this is a scene where the woman is powerful and the others are accompanying her. The men are accompanying her. This is the scene in the Kalavantulu area, the coastal Andhra area at least. Now, I know they never danced. The men did not dance. Even in the Bhama Kalapam, when the character of Krishna had to be done, it was a Brahmin scholar, generally the scholar who wrote the script who came and did that character, or somebody else who came, because there was no dancing there. It was singing and saying the padyam. They did that and they went. It's not the same in Tamil Nadu. I know it's not the same.
Yeah. Okay. Yeah. Thank you, Akka.
Thank you.
Thank you.
Akka. Thank you so much for coming, and we wish you that you could stay till the end, but I know that you have to go.
I really
Thank you, Akka.
I
think Donovan...
Thank you, Geeta ma'am. That was very good.
Thank you, Ms. Yashoda. Such a pleasure.
Just call me Yashoda and I'll call you Geeta.
Okay, such a pleasure.
Same here, Geeta. Thank you.
Meeting you. And I hope we get to meet sometime.
Yes. I really need to.
Please be in touch. They have my email IDs at all.
I will, Geeta. Thank you. Thank you, Maha and Aranyani. That was fantastic.
Thank you.
I think Donovan wants to say something.
Yeah, just before that, I just wanted to say that there's a comment in the chat box from Dr. V.R. Devika saying during the 1927 Act, there was no Rukmini Devi Arundel in the picture. The dance suffered, but Mutulakshmi Reddy kept saying the art will continue outside the dedication. So that is Dr. Devika's explanation of I think the discussion that was going on at the time. I did have one small comment to make about that. I don't know if there would be anybody else who'd like to respond, but I think that the question is that the dance form will continue outside of the dedication. I mean, we're all very glad that it did, but I think the question that we were trying to address here is whether the art form could continue within the communities that were disenfranchised and whose livelihoods were taken away. What did the act or any of the legislation, was it able to achieve that? Was it able to allow the art form to remain within the community? And letting the dedication aspect of it, getting rid of the dedication aspect of it and getting rid of the forceful dedication, getting rid of the exploitation, but not also extracting the dance form. Because as Yashoda Akka was saying, her opinion is that this was a deliberate design. I'm not sure. I'm not sure whether that is true or not true, but I do know that's a valid. Yashoda Akka is saying that she has must have a valid reason for saying so if she feels that it was deliberately taken away by design. So I think that further adds to that question of why couldn't the legislation happen in this manner, where the dedication could stop, but the dance form could remain within the communities. I think, yes, sorry, I'm rambling on. I think Donovan wanted to say something.
Hi, yeah, thanks very much for this very interesting presentation. It's been very interesting to have a look at the analysis of this act. I just wanted to mention that I've been fine combing a number of, well, I'm talking about hundreds of texts that stretch from about 250 years before 1947. And, you know, this was a cumulative hysteria that built up over the course of centuries, really. And what happened around, let's say, the 4 decades before the act, or let's say 50 years before the act, was that it all came to a head. This hysteria came to a head. It was very much based on westernized notions of sexual normative practice, you know, monogamous sexual practice, and their own experience of prostitution in their own countries was a massive problem. And in fact, European prostitution in India at the time was a big problem too. So this was very much on the forefront of not the colonial administration. You know, they didn't really want to deal with this. It was not something they wanted to touch. It was really a minority issue. It was a minority issue that involved reformers in India that had come from 1830 already, and then the Christian missionary sector, which was hugely vociferous and hugely active in this. And the interesting thing here is that if I look at the documentation, it never looks like it's a majority issue. It's not like the whole of India is up in arms and wants this legislation. It's always a small minority of activists that hammer this thing through and that carry it through and that internationalize it and that put pressure on government, put pressure on the administration, and so on and so forth, until this minority group, both Hindu and Christian and other reformers, join and become embodied in the person of Mutulakshmi Reddy. You know, she in a sense becomes the obvious instrument for carrying this through because of her own personal history and background. And then secondly, you know, because she really developed quite an obsession about this. I mean, if you look at her writing in her work, My Experience as a Legislator, for example, you see how much of that work is devoted to the whole question of Devadasihood. And if you look at the letters that she wrote to Young India, you know, the periodical at the time, you find that she's obsessed with this question, which is why in the end the law as it looks, you know, it's such a hatchet job. I mean, I think we would all agree that it's completely incomprehensible in the sense that there were very fine distinctions to be made between various classes of temple servant, of female temple servant, and there were actually people at the time who were capable of making those distinctions. One of them was Otto Rothfeld, who was writing in Mumbai at the time, who understood very well that there were distinctions between various types of Devadasi and so on and so forth. So there was an understanding that would have made it possible for these legislators to give a more refined law, you know, to provide something that was more refined and that really aimed at the heart of the problem. But you see, the heart of the problem was that the reformers needed a visible symbol for the evil of prostitution in India. They needed a star. You know, the problem of prostitution was so amorphous. They couldn't get a grip on it because it was really everywhere and it was horrible. I mean, it was, as it is everywhere, you know, it was a horrible problem in the sense that it involved terrible abuse and so on and so forth. Look, I'm not talking about the kind of regulated sex work that we have in the world today and so on and so forth. I'm talking about what it was like back then with people actually literally on the streets behind bars, you know. Now, this was a massive problem and it couldn't be embodied. So it had to, so a scapegoat had to be found. And that scapegoat was found in the very visible person of the Devadasi. Why visible? Well, because, for example, the Prince of Wales would go and watch a performance. You know, the administrators would go, whenever they had a public function, there would be a nautch, you know, a nautch, a dance. And so this was a tool that could be used to get at the administrators, you know, to begin to move and shake things. And she became a scapegoat, you know, the Devadasi became a scapegoat in this process. And that's why the law ends up looking the way it does. It's deliberately designed, not so that, well, I don't personally see any evidence that it was designed to transfer the dance into the hands of someone else. Because if you look at the writings of the reformers, such as Naidu, Venkataratnam Naidu and others, they actually find fault with the dance itself. They say that the dance itself is an obscene art. I'm using the word that they're using. So they're saying the dancer is dancing to obscene songs. The gestures that she makes in the course of her performance are lewd and lascivious. So the art itself does not want to be appropriated. They actually aim to destroy the art itself because they see that as one aspect of the evil of this Devadasi practice. They don't see the art as something separable. They see it as something integral and inherent to the practice. And they also speak about, once this evil has been done away with, we must refine our music. We must change the lyrics and so on and so forth. We must make them less lascivious and so on. So you see the kind of direction that was given in an underground way to what eventually happened with the so-called revivalists. They had to do all kinds of things to make the lyrics more acceptable and the presentation of the dance more acceptable and so on and so forth, because the art itself was actually criminalized. It was morally condemned and criminalized. So no one would want to take that. No one would want to have that dance transferred into their sphere because it itself was considered lewd. So I just wanted to add that, that this let's say this 250-year history is what led to this legislation. And yeah, it is possible, and I think it's desirable that some form of rectification. I'm not talking about some sort of social justice tokenism or harsh interactions within society or so on, but there needs to be some kind of reparation made in some sort of statement in terms of which the thing becomes more refined, the thing becomes more explicable, so that the dance world can move on and not have to, discuss again and again and again what happened back then. That was all I wanted to say, but thanks for giving me the opportunity to say it.
Thank you.
Thank you, Donovan. Thank you so much, as always, with your very nuanced and multi-layered kind of contributions to our discussion. Thanks a lot. I think, given that there aren't many more questions, does anybody have any more questions or comments? Please raise your hand or speak up. We're trying to skim through all the people on the...
I think Geeta wants to respond to this.
Who does?
I thought Geeta wanted to respond to Donovan.
No. I'm
very,
very stunned with all the information that I got from you, Mr. Donovan. It was so much.
Yes, thank you very much for allowing me just to clarify that. The thing is, it's so intensely interesting to look at the history of the texts because there are so many texts involved. I've been dealing with about 400 sources here. And at the moment, I'm compiling the texts, and I have about 300 at hand that stretch from 1298 to 1930. And they show, when you isolate the texts like that and you place them in a chronological sequence, you begin to see that there's a pattern, a trend, and an evolution towards this last, what I call hatchet job of an act, because it really was that. But you see how the cumulative force of those many little thoughts, those many little writings, and those many little tendencies in the development of the way the dance and the Devadasi was perceived ends up in this complete act of destruction that was supposed to be the result of a social justice campaign, but was in itself utterly unjust. And that's what makes it, one of these big tragedies of history. And I hope that, as I said, something at least can be done to clarify that in the end, you know, something official, something formal.
All right, thank you, Donovan. I think that we can probably close the session if nobody else has any more to say.
If nobody else has.
I think we'd like to just end by saying, first of all, thank you to everybody. And thank you, Geeta, for coming here and explaining us the legalities of this whole thing. And I mean, I think it was actually really important because, as you said, the legal language is actually quite confusing. And I had understood the act when I read it. Some parts of it I felt were repetitive, but then when you explained it, then I was like, oh, okay, so this is different from what Section 1 was different from what Section 2 was, and there were certain things that were appearing to be self-contradictory, but then you clarified those with so much clarity, for the lack of a better word. Yeah, so thank you very much for that.
Thank you.
I think for us, the reason why we had this discussion today was definitely not to take sides or to kind of vilify anybody or to say anything about, to make moral judgments about either the reformists or the hereditary dance communities. I mean, I think that this particular discussion is replete with moral judgments about all of the people involved in this. There are people that really think that they'll go all out to criticize Dr. Mutulakshmi Reddy for what she did, and there are a lot of people that will go and vilify what the Devadasis or the hereditary dance communities were doing. And actually, they're two separate issues, and this is the whole thing. Why did they get mixed up? Is the reason why we were trying to kind of get into this discussion, and even that from your discussions and from what Donovan has said and what Yashodaka said and people have commented has made it clear. But it is definitely, I mean, we do not want to say, our intention was not to say that dedication should not have been stopped. We're not trying to say that, yes, let's all go back and let's become dedicated and let's all become Devadasis again and start dancing in temples. But I think, and neither are we saying that... well, I mean, that's the crux of it. This is the criticism that a lot of discussions like this get. Well, do you want to go back and do that? No, it's not that. But we don't. But also there is a lot of pain and a lot of trauma and a lot of a lot of stigma, yes, and lack of sort of reparation or acknowledgement of this side of what happened to the act. And I think we were trying to kind of, in our little way, trying to bring out those things as well. And so I just wanted to thank you. And Maha, please.
No, I just want, when you said everything that you have to say, but I just want to thank Geeta, Ramaseshan once again for the kind of sensitivity she brought into this discussion. She dealt, because there are hereditary artists amongst, there was Vaishnavi, there was Akshaya, and she dealt it very sensitively, and we really appreciate and thank you for that. And that means a lot to us.
I really enjoyed being here with you today. Never interpreted this law. Even looked into it, forget interpretation.
Yeah. But so that is something that I wanted to add. And once again, I would like to thank Donovan and Yashodaka for participating in this discussion. Yeah, and that's about it.
Yeah, and thank you all. Thank all of you for coming on a Saturday afternoon to attend the session. And we hope to see you for our next one.
We will be happy to share with you the material that we spoke of today. If you require, please drop us an email at recognizingdance@gmail.com. Yeah. Thank you so much.
Thank you. Good night.
Thank you, Donovan. Thank you, Geeta.
Thank you.
And I once again would like to acknowledge the hereditary practitioners of this art form, past and present, before we close this session.
Yes.
Thank you so much. Yeah.